Hi everyone, in this case reading video we're going to be looking at the Turner and Bladin case, which was to do with a contract for the quarrying of a quarry. To do with a contract that involved a quarry. Okay, I'll just leave that. Oh dear. All right, let's do it. Okay, so in this case, there was a question of there being some part performance of the contract, and also more specifically, there was a question of whether specific performance can be ordered for a threatened breach of contract. So where, for example, as in this case, money is owed, but it hasn't fallen due yet. Okay, can you get specific performance in those circumstances where the breach hasn't actually happened yet? Okay. All right. So, as mentioned, this case involved a quarry. Here, the seller of a quarry or right to quarry sued for installments of the purchase price. So the contract was required to be in writing, but here it wasn't. However, there had been some acts of part performance. So the contract of sale had been completely performed by the vendor. The vendor had started to quarry the land. They'd entered into an arrangement with the owner of the land to do the quarrying, etc. Okay. The key question that arose on the facts was whether the seller of the business could sue for the remainder of the unpaid purchase price. So here, I think it was something like, was it 500? Yeah. So £500 was due for the quarry every 6 months, and the total purchase price was £7,500. So the question was whether the seller could sue for the remainder of the purchase price, even though the time for performance had not yet fallen due. So essentially, can they get specific performance when the obligations of the other party under the contract haven't actually been breached yet? In their defense, the purchaser claimed that the contract was uncertain because there was that arrangement that I mentioned where they had to actually get the license from the party who owned the land, so an unrelated third party. So because they had to seek that out, was the contract actually uncertain, and the court rejected that argument here. And they also said that the contract was subject to a condition that had not been fulfilled yet by the seller, being around that license. I believe it was the contract required them to help them get the license from the owner of the land. But in this case, the owner of the land seems to be a very relaxed person, and they just organised it with the purchasers, so there wasn't a problem there. In terms of what was held, so the availability of specific performance was the key issue in the case. And in terms of what was held, it was found that it wasn't a defence to specific performance, that some of the contract was not immediately performable. So it didn't matter that those payments, those £500 payments hadn't fallen due yet. As soon as there is a threatened breach of a contract, a court can order specific performance. So that's the important thing for you guys to take away. This equitable remedy, like with injunctions, can arise where there's simply a threatened breach of contract. The breach doesn't have to have happened yet. And you need to keep this in mind, because this is why, or one of the reasons why, these equitable remedies are so useful to a plaintiff, because they don't actually have to wait for the breach of contract to happen before they can try and, I guess, get their preferred outcome. All right, so let's have a look at the case reading questions then. Okay, so the purchaser raised two defences to the claim for specific performance. What were these? The first defence was that this was simply a money claim that's only just justiciable. It's a difficult word. Justiciable in law, but not in equity. Okay. And the second defence was that specific performance is not available until the money obligations of both parties have become performable. Okay. In terms of the next question then, so in what circumstances can a vendor sue for specific performance of the purchaser's promise to pay money? And you can see the answer to this at 473, where it states that where the contract is of such a kind that the purchaser can sue for specific performance, the vendor can also sue, although the claim is merely to recover a sum of money. So you can use specific performance to recover installments, money owed under a contract. Although you should note that the more typical case is that specific performance is used in the instance of a unique chattel, such as in the Dugan and Lay case that we looked at already, which was to do with that taxi license, which was a unique good. It was difficult to get. There was demand for the licenses far exceeded the supply. And also in instances of land, because land is seen to be so unique, it's difficult to substitute just with another property. So, you know, whilst you might not always be able to get a specific performance in the instance of a money claim like here, it is possible and it is within the court's discretion to do so. So having a look at question 3 then, when can a contract that is not immediately performable be the subject of proceedings for specific performance? And you can see the answer to this around 472 and 473 of our reading, where the court states that we reject the contention that a contract not immediately performable is not capable of specific performance. Proceedings for specific performance can be commenced as soon as one party threatens to refuse or actually refuses to perform any promise for which the time for performance has arrived. What order will the court make in these circumstances? The court can then make a decree that the contract ought to be specifically performed and can mould its decree and order such inquiries, accounts and other proceedings as may be necessary to carry into effect all promises of both parties, whether presently performable or performable in the future. A vendor whose purchase price is payable in instalments, some of which are not yet payable, can obtain a decree for payment of the instalments that are overdue, and the plaintiffs to have liberty to apply in respect of future payments as they become payable. Okay, so you can have a read of that at 423 and 473 and 472. Okay, all right.